Hello everyone, welcome to this session, and now dealing with this course that is Understanding Competition Law Theory and Practice. We are now in third week, that is third module of this course, and we are dealing with the second lecture of this particular module, where today we'll take up the session related to the essentials of anti-competitive agreement. The objectives of this particular session is to identify the elements of anti-competitive agreements and to discuss the meaning of the term agreement. So before dealing with this essential of this anti-competitive agreement, may I remind you the previous lecture in which we have discussed the meaning of the term anti-competitive agreement. If you remember, we have discussed the term anti-competitive agreement such as not defined in this act anywhere, but section 3 subclause 1 is about the prohibition of any activities or agreement which may comes within the meaning of anti-competitive, and if any enterprise or person enter into such type of conduct, it may be void if having adverse impact on competition within the India under section 3 subclause 2. So if you remember in last session what we have discussed, the section 3 is related with prohibition of anti-competitive practices, and in anti-competitive practices, the prohibition related to anti-competitive practices, section 3 is divided into 5 subsections, and particularly in order to understand the better understanding for the purpose, we have decided to categorize it into 4 aspects. The first is the general provision related to the anti-competitive agreement which deal in section 3 subclause 1 and 2, and the second one is prohibition of anti-competitive vertical agreement, section 3 subclause 4, and horizontal agreement in subclause 3, and exceptional clause in subsection 5. So in last session what we have discussed only the meaning of anti-competitive agreement, and we found that section 3 subclause 1 is only discussed that no enterprise or association of enterprise or person or association of person may enter into an agreement regarding production, supply, distribution, storage, acquisition or control of market, and any such agreement entered would be otherwise void. It means if you see the bare reading of section 3 subclause is applicable to whom or applicable for what? Applicable to whom, that means it is applicable to the enterprise or association of enterprise or person or association of person, and the basic object is it basically the prohibition to entering into any agreement, whether it restrict the every kind of agreement or it prohibit the every kind of agreement. No, it only either on the agreement or prohibition or entering into the agreement which have some adverse impact on market within India. So that in last class we have only discussed or deal with the meaning of anti-competitive practices and the term person and enterprise, and the term person which was deal with the section 2 subclause L, where person means any natural person, any government entities, any private entities, any artificial person, that means, and which cover within the meaning of any government entities. And again the term enterprises we have discussed in last lecture. We have discussed the enterprise means any enterprise, whether it is private or government enterprise, any corporation or anything or any entity having the economic activities. If any economic activities is going on or doing with the or dealing with the economic activity, that may comes within the meaning of enterprise, and this is applicable on enterprise and person or association of them. So with this, if we continue with this today's session, what we are dealing with in this session, that what are the essential of anti-competitive agreement. So again, if you see the section 3, it is like it makes clear that there are two essential aspects or requirement to bring into the operation, means that should be a agreement, and that agreement should cause appreciable adverse impact on competition within India. Means if you again see the section 3 subclause 1, it is like it prohibits the any enterprise or association of enterprise or person or association of enterprise in relation to supply of goods, services, storage or anything to enter into agreement having adverse impact market in India. And section 3 subclause 2 is like if it is in contravention of section 3, it will be void. It means if anything, any agreement take place in contravention by the enterprise or person having the appreciable adverse impact, it may be void. So that to bring into the operation the section 3 subclause 1, you have to prove that there were an agreement, and thus agreement, mere agreement is not important. The agreement had some adverse impact or should appreciable to some adverse effect on competition within India. So with this, we can say there are two elements of anti-competitive agreements, the agreement and the agreement should cause appreciable adverse effect. So take term by term. So let's start with the term agreement. What is agreement, or what do you mean by agreement? Agreement is basically a general term. What we have already deal with the agreement in any institutes, like any other institute. If you remember, you must go on with the Indian Contract Act, where agreement is defined from the statute as a statutory provision for the purpose of legality. So that agreement is a very generic or very general term. Agreement just means if one make offer and other one accept the offer with some consideration, they comes with the promise, and the offerer and the acceptor, if comes within the same meaning against some consideration, it may be an agreement. But under this act, agreement, which is not defined actually in this act, but for the purpose of agreement, agreement refer to an agreement. It is section 2 subclause 1 which is applicable in terms of agreement in this act. Means the term agreement, what we have gone with in any other act, or like the Indian Contract Act, there was a particular meaning, but for the purpose of this act, agreement means some unique meaning, and this unique meaning is given under section 2 subclause A. So while dealing with section 2 subclause A, if you see, the Competition Act define the term agreement, or which may refer as any arrangement or any understanding between two or more parties that has the purpose or effect of restricting competition in market. As per section 2A, the Competition Act, an agreement includes any arrangement or understanding, whether formal, informal, written or oral, and any agreement or arrangement between two or more parties, or any understanding or practice that has the purpose or effect of restricting competition. So here the term agreement includes a wider range of activity. If you remember the agreement within the meaning of Indian Contract Act 1872, there was a distinct meaning of the agreement. But for the purpose of this act, agreement even includes any type of arrangement if it takes place between the two persons, or the enterprise or association of enterprise, or persons or association of person. Even it includes any understanding, that means you have not deal with the that means it is not required to evidently you have to prove where that there is an agreement. Only the arrangement or only the understanding if between the two person or two enterprise or person and enterprise and the conduct is like anti-competitive practices, it comes within the meaning of agreement. It must not be formal, informal. It may be in any form. It may be in written, oral, formal, informal, arrangement, understanding, consent. It only requirement is the existence of the parties. If there is a existence of the parties and the conduct of the parties are showing like that there were definitely some arrangement or understanding between two parties which you cannot prove on documentation or by the evidence, but you can trace the impact of such understanding on the conduct or the impact on the market by such conduct if the activities or the output or the ultimate object is like the distorting the competition. So that any understanding, any arrangement, any practice which has the purpose to effect the restricting the competition, it must come within the meaning of agreement as per section 2 sub clause A. So, it is clear that by the definition which includes any arrangement, any understanding or action in concert, means by bare reading you are finding there are three important terms which has been used to prove the agreement, that may a mere arrangement, that may only the understanding, or that could be a action in concert, whether formal or in writing or is intended to be enforceable by legal proceeding. Thus, it may be noticed that the definition is inclusive, not exhaustive. The definition is not limited to legally enforceable contract as defined in section 2H of Indian Contract Act 1872, because it covers both formal and informal agreement, whether express or implied. Such agreement may or may not be enforceable by law. Thus, the term agreement has been worded in a wide manner, and the agreement does not necessarily have to be informal of a formal document executed by the parties. Thus, there is no need for an explicit agreement, and the existence of an agreement can be inferred by the intention and objectives of the parties. The agreement is the factum rather than the form in which such agreement or understanding is reached, and in order to ascertain the existence, the whole context must be looked upon or looked into. In the case of oral or informal agreement, the proof will generally be based on the examinations, evidences, and the circumstantial fact and parallelism of action between the competitor or the enterprise that can indicate this. That means the important thing is not where you have to see that there is yes existence of agreement. This is not important for you to prove that there is existence of agreement or agreement is not. You have to only go with the circumstantial fact evidences on that forum, that if there was the existence of the parties and they have taken into any arrangement which have some adverse effect on market, you can trace it that yes, no doubt there will be definitely some type of arrangement or agreement, whether it is not formal or informal. Mere understanding may be for the purpose to fix the price or anything which is against the anti-competitive practices. So that here the terms are important. The terms which has been used under this, like if you see the arrangement. An arrangement refer to a mutually accepted plan or scheme between two or more parties, which may or may not be formalized in writing, and it can include an understanding, and here understanding refers to a shared awareness or knowledge between two or more parties which may or may not be explicitly stated, and it can include any tacit agreement or implicit understanding, a shared assumption or expectation, or any mutual awareness of each other's intention or goals. An arrangement or understanding could be in any way or form, but it must result from some communication between the parties or some meeting of their minds. Arrangement in something whereby the parties to it accept mutual rights and obligations. When behavior of the traders seem consistent with a mutual understanding of some kind, the conspiracy, communication, or at least concern could be inferred. As an illustrative or illustration, you may see Messrs. Bharti Airtel Limited versus CCI, the case of Competition Commission of India, that is of year 2012, where the CCI observed that a telecom service provider's understanding with the distribution and retailers constituted an agreement under the Act. The concert means the certain traders combine together to fix the price of a commodity or raise the price at the same or about the same time. The intention is to limit competition among themselves. That means a feature of concert is that the price of the commodity is fixed not on the basis of the supply and demand, but in the market, but by the understanding. That means concert, which has the term which has been used, concert action, it does not means, or it means, you can say, it is like the fixation of the price by the understanding between the enterprise or person or association of them, where they actually raise the price of the commodity or the service at the same time, or at the same, eventually at the same event, or it is like the at the same time, at the same scenario, when the price of the one commodity or product or service has been raised by one enterprises or company, you may surprised to see that the price of the commodity or the service of the same product has been raised at the same time by the other entities, so that by this fixation of rising of the price at the time, at that time, you have nothing to do, and you are that means you have to take that commodity or service at the same time, at the same price, which is the raised price. That means if the commodity or raise the price at the same time about the same, the intention is like to limit the competition among themselves, because they just wanted to limit their competition, and this is like the feature of consent, and you have not to prove that there were an agreement in formal or written. This implication reflect that yes, there is something which is like the arrangement or understanding between such enterprise, because these activities is fall within the meaning of anti-competitive practices, and as a result this has take impact on competition within the market in India. So that as illustration, you may see the CCI in the case of Messrs. Pooja Enterprises and others, that has held the definition of agreement to be wide one. The CCI of the view that understanding may be tacit, and the definition covers situations where the parties act on the basis of nod or a wink. There is rarely a direct evidence of action in concern, and the Commission has to determine whether those involved in dealing had some of undertaking and were acting in cooperation with each other. And in the light of this definition of the term agreement, the Commission has to find sufficiency of evidence on the basis of benchmark of preponderance of the probabilities. That means what we are discussing here, you have not to prove or you have not go to detail whether there is an agreement or not, where there is a formal, there is a writing or not, there is something you have to, you have not to prove this. You have to see the circumstantial, that you means the CCI. The CCI, which is the regulatory body, is just take care of the circumstantial fact and the result and on the basis of probability. That means if the inquiry takes place, it takes the each and every step impact and assessment, and the assessment is like that there is a probability of such consent or understanding or the mixing of the opinion of the person which have an impact as adverse impact of market in India. CCI may assess that yes, there is like something wrong which form the anti-competitive agreement. And there is another case, the case is what we have dealing with, the Pooja Enterprises is of year 2013. You may go with the detail with the citation which is here. Some more example, if you see, suppose two airline agreeing to charge the same price for a flight between Delhi and Varanasi. What is this? Suppose there are two airline, if there are two airline and if there is a competition or intention of competition in airlines, you may have as a consumer an opportunity to choose as a variety. That means you may take A or you may take B as per your choice, as per your demand, as per your time, or as per the basically the price or the traveling fee. But surprisingly, what you found that there are two airline of two different companies or the enterprise, but at the same price between Delhi and Varanasi. How is it possible? But yes, if it is, there may be something wrong. If suppose there are two network company, if there is actually competition, they will compete with each other by providing good services, product, commodity or good network or anything which is in good for the purpose of inviting the customer. But if you find that there are two network companies and agreeing not to compete in rural market, what is this? This is like a conduct which comes within the meaning of anti-competitive practices. Again, a bike manufacturer, its dealers agreeing to fix the minimum price at which bikes can be sold. That means this is nothing but the fixation of price which comes within the meaning of anti-competitive agreement. And again, one more example, suppose a group of wholesaler agreeing to boycott a particular supplier. What is this? This is like an conduct which may comes within the meaning of anti-competitive activities. But the problem is section 3 subclass 1 and section 3 subclass 2, you have to go with both in a one picture or a one frame, because section 3 subclass 1 is only prohibit to entering into any agreement which have adverse impact or likely to be adverse impact on market and competition within India. Then it may comes as, that means it may be void as per section 3 subclass 2. So that merely entering into agreement by the enterprise or person does not automatically comes to be an void until unless it has some impact, adverse impact actually on market within the India. So the important point is the examples what we have taken in generally considered as anti-competitive agreement as a natural, but actually if you have to prove there is an agreement and this is an agreement which is adverse impact on competition within India, so that you cannot find that there is an agreement if there is a traveling fees or journey fee or the fare of the airline is the same by two airlines. It may be coincidence. So if you wish to prove that the two airlines agreeing to charge the same price for the flight between Delhi and Varanasi, you have to prove that it will impact adversely on market. So that there is a one case, that is CCI versus Hindustan Unilever Limited, where the fact is Hindustan Unilever Limited has exclusive agreement with the distributors, restricting them for dealing with the competing product. The CCI assessed whether these agreement caused an appreciable adverse impact in the market, and CCI held that the agreement did not cause appreciable adverse impact as they did not lead to foreclosure of competition. That means merely entering into agreement, this is not important. The important fact is there is an appreciable adverse impact. So this is an important feature where you have to prove that there is a fact that the agreement, and by the agreement the adverse impact has been taken place. One more case is CCI versus Google India Private Limited, decided on the February 8, 2018, and the fact was like Google India Private Limited had agreement with the advertising partners which restricted their ability to deal with competing advertising platform. The CCI assessed whether these agreement caused appreciable adverse impact on market or not, and the CCI held that agreement did not cause the appreciable adverse and they did not lead to foreclosure of competition. Again, like the previous case what we have seen, that there is no anti-competitive practices, whatever anti-competitive practices or not, but because that does not lead to adverse impact on market on competition, so does not come within the meaning of anti-competitive agreement and does not abide as per section 3 subclause 2. Again, one core case, that is CCI versus Flipkart Amazon, decided on February 2019, and the fact was like Flipkart and Amazon had exclusive agreement with their seller, restricting them for selling product on competing e-commerce platform. The CCI assessed whether these have caused appreciable adverse impact on competition in market, and CCI held that the agreement did cause appreciable adverse impact and they lead to foreclosure of competition and had drove existing competition out of the market. So by these illustration, you may conclude it like the basic test to qualify whether the agreement is anti-competitive or not is whether there is appreciable adverse impact or not. If there is merely an agreement or may not be agreement, but if there is no adverse impact on market or competition, may not come within the meaning of the anti-competitive agreement. So with this, we are holding this session here. And in next session, we will discuss the meaning of appreciable adverse effect on competition within the India, and it will be the true test to find out whether any agreement qualify within the meaning of anti-competitive agreement or not within section 3 subclause 1 and 3 subclause 2. So with this, for today, thank you.